I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Another disastrous day in court for Donald Trump after a disastrous midterm elections where Trump endorsed candidates and MAGA extremists by and large were repudiated by the American electorate. This time in court, a court of appeals has denied Donald Trump's initial request for an appeal of a lower state court order in New York State Court by Judge Arthur Engoron, granting the New York Attorney General Letitia James request for a preliminary injunction, which will appoint an independent monitor to oversee and to review all of Donald Trump's financial filings, to make sure that Donald Trump is not engaged in any fraudulent conveyances of assets to related third parties, and to review Donald Trump's submission of future Statement of Financial Conditions, SFCs, to third parties such as lenders. That independent monitor is Donald Trump's worst nightmare, which will inevitably prevent him from trying to engage in the type of misconduct and mischief and fraud that he has been known in the past to engage in regarding his financial dealings. And so Donald Trump's lawyers, Alina Habba, and other lawyers from his team, filed this application with the Appellate Division, First Department in New York State Court, requesting an appeal. They said the appeal is taken from each and every part of the decision and order reached by Judge Arthur Engoron the other week. They claimed in this application, Donald Trump's lawyers claimed that they wanted a stay of the decision and order because there was a strong likelihood of success on the merits, and absent a stay, appellants will be severely prejudiced and will suffer irreparable harm. And here, in basically a one-sentence handwritten order, the Appellate Division said, nope, we are not granting you a stay. A stay would temporarily block the appointment of the independent monitor. That process is taking place based on a process set forth by the lower court, Judge Arthur Engoron. However, the appellate court did say, though, that the application for an interim stay is denied. However, it will be pending a determination of the full bench of the Appellate Division, so a larger group of judges on an expedited basis. But Donald Trump wanted to stop and slow down the process of this independent monitor being placed within the Trump organization immediately. He is flailing and has become even more deranged and out of his mind since Judge Arthur Engoron reached this decision the other week to appoint an independent monitor. But here, for now, the stay application is denied. This will now go before a larger bench of judges in the First Appellate Division. But the good news here, and now let's just pull up Judge Arthur Engoron's order. And in Judge Arthur Engoron's order, it was reached November 3rd of 2022. And Judge Arthur Engoron sets out a process for the appointment of the independent monitor. And so the appointment of the independent monitor, we will go to the conclusion section, and it says, the court will appoint an independent monitor from names recommended by the Office of Attorney General, by Letitia James's office. By the way, Letitia James won her re-election the other night, which is bad news for Donald Trump, and defendants, in this case Trump, who shall have until November 10th, 2022, to identify no more than 3 potential monitors for the court's consideration. The party shall then have until November 15th, 2022, to comment, if they so choose, on their adversaries' selections. Once a monitor is appointed by this court, the monitor shall remain in place until further order of this court. So what was Donald Trump trying to do by requesting the interim stay that was denied? Trump wanted to try to delay, and to derail this process because on November 10th, Donald Trump and the Office of Attorney General will submit the names of potential independent monitors. They will then have until November 15th to comment on each other's selections, and then Judge Arthur Engoron will make a finding. And just so you recall, why are we talking about this preliminary injunction where there was this order for this independent monitor? You will recall a few months ago, the New York Attorney General's office, led by Letitia James, following a 3-year special proceeding that investigated the Trump Organization and Donald Trump and his adult children for fraudulent business practices, initiated a blockbuster lawsuit seeking at least $250 million in damages based on the fraudulent conduct that was discovered in their investigation. And the fraudulent conduct at issue relates to fraudulent valuations by Donald Trump and the Trump Organization and his adult children, it is alleged, of the Trump properties, the various Trump properties. And so the allegations are, for example, that certain property would be appraised at X dollars, yet on the statement of financial conditions submitted to lenders in order to get benefits, there was fraud that was committed where Donald Trump and his adult children and the Trump Organization, various forms, would give a valuation of Y, which was a grossly inflated valuation. So I'll give you an example. A group of 12 apartments that were rent controlled that had an appraised value of $750,000. The Trump Organization claimed on its statement of financial condition had a value. They lied about it and said it was a $50 million valuation. Similarly, Trump's triplex in Trump Tower, Trump claimed was 30,000 square feet when it was in fact 11,000 square feet. And when there was an appraised value of less than $100 million, Trump, on his statement of financial condition submitted to lenders and other third parties, said the valuation was somewhere in the range of $200 to $300 million, which exceeded by essentially multiples the highest valued apartment in all of Manhattan, which this clearly was not. And one of the ways Trump got there was by also inflating the square footage from 11,000 to 30,000 square feet. There's countless other examples where, by hundreds of millions of dollars, Donald Trump inflated the valuations of his properties. Now, in connection with the special proceeding before the lawsuit was brought, Donald Trump had an opportunity to defend himself, to defend the valuations that he was giving on his statement of financial conditions. Tish James subpoenaed him for deposition. He tried to avoid the deposition. And finally, when he sat for deposition and he was asked very basic questions like, what was the appraised value of this property? And what was your valuation for this property? And why did you make that decision? Now, if you weren't breaking the law, it would seem pretty obvious and easy to answer those questions. But what did Donald Trump do? For over 400 questions, for every question he was asked, he pled the fifth. He invoked his Fifth Amendment right against self-incrimination. He refused to answer. And in a civil action, that is an adverse inference. The judge and a jury at a later time can infer that the reason that he is not answering those questions is because he is hiding bad conduct. They can draw an inference that is adverse to the party who's invoking the fifth. You can't do that in criminal proceedings to draw an adverse inference when someone invokes their Fifth Amendment rights. You can't do that in a criminal proceeding, but you can draw an adverse inference in a civil proceeding. Now, after filing the fraud lawsuit against Donald Trump, his adult children, and the Trump Organization, Letitia James argued and discovered Donald Trump is engaged in ongoing fraudulent conduct such that we need to have an independent monitor observe what the Trump Organization is doing now, someone who can observe the financial statements they are currently still making, the representations they are making to lenders. We need to also ensure that the Trump Organization and Trump and his adult children aren't engaged in fraudulent conveyances, because as soon as Letitia James filed the lawsuit against Trump and the Trump Organization, Trump created a new company called Trump Organization 2, which looked like he was planning on making fraudulent conveyances of assets from Trump Organization 1 to Trump Organization number 2. Now, in addition to having the opportunity to defend himself at his deposition and answer those very basic questions that I just told you, at the preliminary injunction hearing that took place on November 3rd, Donald Trump and his lawyers had the opportunity to introduce evidence. You know that concept, evidence, because that's what takes place in our court system. I can tell you as a lawyer, I've been on the side that has sought preliminary injunctions before, and I've had clients who were on the receiving end where someone sued them and wanted a preliminary injunction. And what you do is you provide evidence. You don't go on social media platforms and whine and complain. In a courtroom, you provide evidence. So in this case, if Donald Trump still wanted to invoke his Fifth Amendment right, sure, go do that. But you can bring on expert testimony, third-party testimony, bring on testimony of people who work for you, like a controller or a VP, anyone at all in the organization, and have them submit affidavits and say, here is why there is this discrepancy. You justify it, because the burden on the New York Attorney General's office here is to find, one, that there is a probability of success on the merits. That's what they have to prove to the court. And then when you balance the equities favor the New York Attorney General, the municipality's request for a preliminary injunction. So first, a showing is made by the New York AG, and then that showing has to be rebutted by the defendant. It happens all the time in courts, but Donald Trump did not do that here. They provided, according to Judge Arthur Engoron, and you saw it in the hearing, so we knew it took place. This is what Arthur Engoron said. Not an iota of evidence. Nothing. No affidavits, no declarations. The only argument that was essentially put forward by Donald Trump and the Trump Organization and his lawyers was that the New York Attorney General did not have jurisdiction to bring the case, which was an awful argument, because jurisdiction is literally in New York Executive Law, Section 63. It literally spells it out. It basically says the New York Attorney General shall have jurisdiction over matters precisely like this. It's spelled out in the statute. And the other argument that Donald Trump made was not that his valuations were accurate, but he also said, look, here is a disclaimer that we gave to lenders when we would lie to them. This is what Trump actually argued. These are the facts. And this is the disclaimer that Trump said was included by his former accounting firm, Meiselas, which he claimed gave him immunity in this case and allows him to lie to third parties when he gives false financial valuation. This is what the disclaimer says. We have compiled the accompanying statement of financial condition of Donald J. Trump as of June 20th, 2012. We have not audited or reviewed the accompanying financial statement and accordingly do not express an opinion or provide any assurance about whether the financial statement is in accordance with the accounting principles generally accepted in the United States of America. Donald J. Trump is responsible for the preparation and fair presentation of the financial statement in accordance with the accounting principles generally accepted in the United States of America and for designing, implementing, and maintaining internal control relevant to the preparation and fair presentation of the financial statement. And the court said, Donald Trump, how in the world do you believe that disclaimer gives you immunity? That's a disclaimer from your accountant firm, Meiselas, which says they're relying on you because they didn't believe the financial representations you were making were accurate. And then what the judge says is allowing blanket disclaimers to insulate liars from liability would just make no sense if that was allowed on statement of financial conditions. And the court goes on to basically say that he finds that there is a probability of success on the merits, that there is ongoing fraud. And get this one statement. This is in the ruling by Judge Arthur Engoron that no doubt the Court of Appeals, the Appellate Division now, and then the future full bench of the Appellate Division is going to look at. This is what it says. In the absence of an injunction and given defendants, Trump's, demonstrated propensity to engage in persistent fraud, failure to grant such an injunction could result in extreme prejudice to the people of New York. Very powerful words by Judge Arthur Engoron. Now, one of the things I've said in my analysis of the midterm elections so far is that in addition to it being a humiliating defeat of MAGA and Trumpism generally, one of the key things I think we're going to see is Donald Trump is left very vulnerable right now to all of these lawsuits, to the criminal investigation. And as I've said before, the wheels of justice sometimes move slowly or grind slowly, but they move in the right direction. Now, more than ever, and I've always felt confident before, I've told you that justice is coming for Donald Trump here. In this case, I also believe through Merrick Garland's current criminal investigations and in other proceedings as well. But I believe right now Trump is as vulnerable as he's ever been because he used to be able to point to the braggadocious, bravado, false narratives that the media love to regurgitate about the power of his MAGA base. Well, we now know. We knew this all along if you're watching the MeidasTouch network, but now I think it is made more clear to others that that just simply isn't the case. We will keep following Donald Trump's flailing attempts here to try to appeal and delay, but the wheels of justice are moving in the right direction. Next step to report on, the parties submitting their selections of independent monitors. Isn't it so ironic, too, that Trump wanted that special master, Judge Raymond Dearie, in the Department of Justice's execution of the search warrant in the federal criminal investigation taking place, where there shouldn't have been a special master appointed, and Judge Eileen Cannon made that horrible ruling where she's eventually going to get reversed, and she was already reversed regarding the 100 classified records that were returned to the Department of Justice. But here, an independent monitor, which kind of functions like a special master, but far more intrusive in terms of its review of the corporate dealings of a potentially fraudulent organization, where a judge reaches that finding, that now we have this independent monitor here in this process where it actually should be taking place. That's what I like about justice sometimes. I love sharing this with you as well. Do me a favor. Hit the subscribe button right now. We're on our way to 1 million subscribers. We just passed 700,000 subscribers. It's free to subscribe, so please hit the subscribe button. And in addition, please check out our Patreon website. Go to patreon.com/MeidasTouch. Become a patron by joining one of the memberships there. There's lots of great exclusive content that you can only see on Patreon. And most importantly, it will help grow this independent media platform. And I think you know, and we all know now, how important an independent media platform is, especially as a result of what took place during the midterm elections. Thank you all very much. I'm Ben Meiselas. Until next time.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.